Okay, thanks. And now I'll finish up on this. I have the final part of this. This is unfortunately one of the more technical areas that we addressed. I'm addressing very roughly matters relating to defences, which covers a fair degree of ground. This turned out to be even more complicated than we originally thought when we went over it, not least because the consultation exercises we did turned up various issues. And the more we thought about the various possible people involved, the stakeholders, to use a term Owen doesn't like, in this area, the more and more issues became apparent. So I'll just go over the most important issues, in my view, in relation to defences. Necessarily, a lot of this is technical. In some cases, indeed, all we need to do is to sort out a technical issue. I doubt that will be particularly controversial, but there will be other things here which might be controversial. So if this seems boring or overly technical, all I can say is that it will be over relatively soon. Various issues then relating to consumer protection, to deal with them one by one. An issue that came up is the question of defences generally and how they relate to any kind of a contract which may seem to restrict defences. The copyright legislation already provides that it's irrelevant, that there may be a contractual restriction on the defence is still there, but the legislation never actually says what happens to the contract in that situation. It's all very well saying the contract is irrelevant, but what happens to it? What happens if the court is asked to enforce it? So, in line with the Unfair Consumer Contracts Directive, we wish to make it clear that a contract, an unfair term in a contract which purports to prohibit or restrict something permitted under the legislation shall be void. There were also some loose ends to tie up in relation to technological protection measures, which we already mentioned. I think all three of us have mentioned technological protection measures at some point in this. The legislation already provides that if you have technological protection measures in place, then they can't prevent acts permitted by the legislation. You can put in a mechanism to protect your copyright, but you can't use that to prevent acts permitted by the legislation, nor can you prevent acts of circumvention which would be necessary to carry out permitted acts. Again, the basic idea is clear and we don't wish to change the general thrust of the legislation, but an additional provision is needed to deal with the case where a consumer is prevented from doing a lawful act by overly protective measures. And we copied a provision from another jurisdiction that allows this to come to the attention of the minister and for the minister to make directions in that situation to resolve the conflict of rights. That's in our draft legislation. So those are the consumer protection provisions. So far as private copies are concerned, here, as a committee, we had a very definite view, may turn out to be controversial, but anyway, if we get shot at, so be it. We were very definitely of the view that so long as we're talking about non-commercial uses, we're talking about uses that don't get in the way of the ordinary exploitation, ordinary commercial exploitation of the work, then users who bought content for personal use have a reasonable expectation of being able to use this content across a variety of formats. And we saw this in comments that were made to us again and again. You could say from one point of view that the general public just don't get where copyright law is coming from, that if they buy a DVD, they naively think, well, I ought to be able to watch this DVD on whatever means I have for watching DVDs. But, of course, to a copyright lawyer, this may involve copying from one format to another. We think that in that situation, the consumer is actually right. If, in fact, they have paid for particular content, we are not convinced that they should be restrained from seeing it in whatever format they wish, merely because they bought it in one format. And the technology keeps on providing different ways to view content. So, the private copying exemptions here, which I'm going to look at in the next few slides, we're proposing that the full range of exceptions in the EU copyright directive should be made part of the law here, that we should be permitting greater use, so long as it is non-commercial use, so long as it doesn't interfere with the legitimate interests of the copyright owner. And we see this across various offences. We propose an exception for reproduction on paper for private use. That's one. Format shifting generally. We feel we need a general provision there. Obviously, we don't feel the need to define the various different types of formats here, precisely because new formats are forever being introduced. It was suggested to us that we ought to draw a distinction here between between viewing content on your own machine and format shifting into the cloud. We weren't convinced, ultimately, that that distinction made technological sense, that it would be possible for us to enact it, even if we thought it was a good idea. Equally, backups. We talk about this in more detail, but again, we thought there should be greater freedom to back up material that you have, which again necessarily involves shifting from one format to another. Other aspects of the EU copyright defence there, use of material for caricature, parody, pastiche, satire. Again, so long as this was non-commercial use, we saw it was appropriate to have an explicit defence there. And last but not least, we thought there should be a general exception here for non-commercial user-generated content. We're well aware that there's no explicit provision for this, but nonetheless we regard this as implicit in the other defences available. I must stress again that this is non-commercial. There's a requirement for an acknowledgement here. There's a requirement for non-interference with the legitimate interests of the copyright owner. So that's one area where we did make definite proposals. Contrast that with the whole matter of intermediaries, where we were possibly a little bit tamer. Largely because there's an awful lot of discussion in this area anyway. We did feel that the whole question of temporary copies, we ought to have an explicit provision, that the case law has moved on since our original provision was here, but we feel that it should be made clear exactly what the position is in relation to temporary copies. But in surrounding areas, we decided to leave, alone here, for a number of reasons. EU Commission consultation in this area relating to existing immunities. New technologies tend to come in there. We didn't feel that there was much we could say about the general provisions here. There are always going to be issues of exactly how these apply to a new technology, but it seemed to us a bad idea to introduce legislation saying that, precisely because the technology changes so quickly. Indeed, one of the functions of the Copyright Council that we saw here was precisely to provide ongoing guidance with much greater speed and much greater surety than legislation very much coming after the event could do. So bearing in mind the other activity in these areas, we didn't think it was appropriate to make any recommendations on those last few points. For linking to material, the view that we proceeded with was that we weren't convinced that a mere provision of a hyperlink was not enough to constitute communication to the public. We were not convinced that merely providing a hyperlink to something amounted to infringing the copyright if it turned out that you were linking to somebody's original material. It's not just us. That's actually a quotation from an English case, and we had a similar view from the German Parliament recently, and there's a great deal of case law on this. Obviously, we'd like to get a definitive ruling on this from the Court of Justice, but the position for now we think is best summed up that way. Linking the linking is not to be regarded as constituting communication to the public. And we suggest that that should be enacted in legislation. A link simply conveys that there is something there and tells you where there is. To treat somebody who provides a link as infringing copyright seems to us to be going too far as a general rule. Of course, it's different if you know that the thing to which you're referring is there in breach of copyright. If the provider of the link knows that the link is to an infringing copy, or ought reasonably to know that there is a link, that is in a different category, and we say so in the legislation. So we propose that a simple link as such should not be regarded as infringing copyright. In practice, of course, people very rarely make a link on its own available. They tell you what that link is, what it's referring to, and that's where our related defence relating to marshalling comes in. We are proposing that if there's a reproduction of a very small snippet of text from whatever you're referring to, placed reasonably adjacent to the link. This would be a very common thing, that you have a link and you have a very small snippet of text explaining what it is that you are linking to. This, again, is not something we thought of ourselves. Actually, it's a very small snippet in the translation of something in recent German legislation in this area, although we propose something which isn't in that German legislation, which is to say what we mean by very small snippet. It sounds like a very small snippet within the meaning of the bill, but we don't see any other practical way of doing it. We define very small snippet of text as being 160 characters or less, or 2.5% of work, but with a cap of 40 words. So we do really mean very small here. Obviously, you're copying things which in principle might be subject to copyright, so when we say that a very small snippet would have a defence, you can turn that proposition on its head and say the same thing. If you go beyond a very small snippet, more than 160 characters or 2.5% of the work, or more than 40 words, then copyright applies. And there is a fair amount of case law, as some of you will know, on copyright in such small snippets. So those two proposals, the linking and a small amount of text to explain the link, go together. So those defences on private use and non-commercial use very much go together. Now we come on to material which is much more related to the explicit terms of our terms of reference. That's in particular in relation to copyright and innovation. We discussed amongst ourselves various ways of approaching this matter of innovation. In the end, in our consultation paper, we took the bit between our teeth and said, well, why not have a defence of innovation as such? Why don't we run this up the flagpole and see what happens? And so we introduced a draft defence, an innovation exception, talking about people who produce a new original work from words which are substantially different from the original work, or which substantially transform the original work. So we put up that proposed defence, and we read carefully what we got back. We have made various technical changes to the defence as a result of those comments to deal with other comments we received. We are not convinced, we don't believe that this infringes the copyright directive. We believe it's entirely compliant with the Berne three-step test. And in many ways, this is limited. Certainly, you don't have a defence just by being able to convince a judge that what you've done is innovative. It is much more restricted than that. It mustn't prejudice the rights of the owner of the original work. It must contain an acknowledgement. There's a duty to inform the owner of the original work, and so forth. Equally, required by our terms of reference was to look at a fair use defence. And the terms of reference actually do refer to a US-style fair use defence. This in many ways was a bugbear for us because we realised fairly rapidly going into it that actually an awful lot of nations have a fair use defence, and focusing on a US style defence was a bit of a distraction in many ways, not least because it encouraged people to take mildly extreme attitudes. Some people say if Ireland introduces a US-style fair use defence, then we'll be a second Silicon Valley. Other people saying if we bring in such a defence, then the sky will fall in, or words to that effect. We found views which seemed exaggerated on both sides of this. So perhaps the first thing to say is, if we're being asked, are we bringing in a US-style fair use defence? Are we proposing a US-style fair use defence? Where we're proposing an Irish fair use defence, which is in many ways different from the US defence. We use the experience, all the experience that's been brought to bear on us, telling us what has happened in other jurisdictions. And the defence we're proposing to bring in is quite different from the American one. What we're trying to do here is to bring in a way of accommodating various rights and interests here in a context-sensitive way. It was also suggested in various consultations that actually we couldn't do this, that it would be contrary to existing EU law. We don't think so. For detail, read the report. But even if we are, then we are proposing that such a defence should be lobbied for. Already the UK and Holland in their different ways are lobbying for a broader approach to fair use within the EU. If it is thought that such a defence were a good idea, then perhaps Ireland should add its voices to that. So I think we should start off with what Ireland would want to do. If we decide that we wish to have a broader defence, but that current EU law doesn't permit it, well, perhaps we should join those nations lobbying for a broader defence. So, the essentials of the fair use defence we're proposing. The point we start off from is to recognise that many aspects of our existing law could be regarded as examples of fair use, many of the existing offences, and so in our draft legislation we point out that other offences may already be regarded as examples of fair use, and requiring a court to consider those other offences before going on to a fair use analysis, and that when the court is considering fair use, it can proceed by analogy to those other defences. Ultimately, under the defence we propose, the court will look at a wide variety of factors. It can look at such matters as the court considers relevant, but we introduce a long list of factors, considerably longer, in fact, than the US list, to make the court look here at the context. One of the complaints made again and again about the US approach was that it was too vague. I'm not sure with the amount of case law they have on it in the US that have built up that's a fair criticism now, but it would be a fair criticism were we to simply bring in a US style defence. That's precisely why we're not proposing to do that. We have something much more tightly drawn, gives a much better idea of what arguments can be made either way. If I skim briefly through the various factors that the court must take into account, the court must look at other existing exceptions to see whether, by analogy, this can be brought within them. It must look at the purpose and character of the use proposed, whether it's non-consumptive or transformative, whether there would be a secondary infringement if the defence were not available. It must look at the nature of the new work, whether there's some kind of public benefit from making it available, looking at the amount and substantiality of the use, impact of the use on the normal commercial exploitation of the work. Are the plaintiff's rights unduly infringed by granting a defence? Here, possibility of obtaining the work or a license to use the work, the interests of the owner, and whether or not there's an acknowledgement of the original work. So we're proposing here a number of factors there to help with the availability of the defence. We think we're proposing something which will give the courts flexibility without introducing chaos, to give the courts a context-sensitive way of addressing these conflicts of right. And always it's working on the basis of existing law, looking for analogies within the existing law. So no doubt there will be some who will still say the sky will fall if we bring in this defence. We think we've paid adequate regard to that. What we're proposing doesn't seem to us to be revolutionary, although it does seem to us to be desirable. So those are the various defences there, and that concludes our session there. We hope there won't be too much blood on the floor as a result of what we have proposed.